Hello everyone, welcome to the first video of our contract practices series. In this video, we are going to learn about the essentials of a contract. This is a very basic and fundamental topic for the contract, but it is very important for all the professionals who want to draft a valid contract. This is also one of the important competencies which is required for becoming a chartered or a certified QS. So if you are working as a project manager, as a contract administrator, as a consultant, it is important for you to understand all these essentials of a contract. Section 10 of Chapter 2 of Indian Contracts Act mentions all the essential elements in an agreement which results into contract. So let us see one by one what are those essentials of a contract. So number one is agreement, that is offer and acceptance. Second is legal purpose, that is lawful consideration, capacity to contract, consent to contract, there should be a lawful object. Next is certainty of performance, possibility of performance, not expressly declared void, and legal formalities like writing, registration, etc. So we will understand all these points one by one in the next upcoming slides. So the first essential is offer and acceptance. What does it mean? It means that there must be two parties forming an agreement and there should be a lawful offer and a lawful acceptance. The parties should have a mutual understanding regarding the subject matter of the contract. Secondly, they should agree over the subject matter in the same sense. There should be an agreement. Next is legal purpose. It means that the parties should agree to form a legal obligations. Like in construction, the employer and the employees or the contractors form a legal obligations, the breach of which obligations can lead to arbitration or litigations. However, the agreements of domestic nature are not contracts as there is no intention to create a legal obligation. Say for example, the agreement or the promises made between the family members about day-to-day activities cannot be considered as a contract because there is no intention between the family members to create any legal obligations. So such domestic nature agreements cannot be considered as a contract. Third is lawful consideration. Before going to lawful consideration in details, firstly understand what is this consideration. The consideration is the price through which the promise of other party is bought. Say for example, Mr. X wants to sell his factory to Mr. Y for rupees 50,000. So for X, the consideration is 50,000 rupees and for Y, the consideration is the factory of Mr. X. Hence here the factory of Mr. X and 50,000 rupees cash that Y is giving to X can be called as consideration. An agreement can only be legally enforced if one party gives something to the other party in order to get something from the other party. It can be an act of doing something or forbearance of doing something, or it may be abstinence of doing something. That can also be considered as a consideration. The consideration should not be unlawful, immoral, or opposed to public policies. So the fourth essential of contract is capacity to contract. What does it mean? It means that a person who enters into a contract must be competent. The person should have attained the age of majority and should have sound mind and should not have been disqualified from any law to which they subject. Minors, lunatics, unsound person or intoxicated person are not competent to enter into a contract. The fifth essential element is consent to contract. The parties entering into the contract over a subject must have agreement in the same sense. There should not be any fraud or misrepresentation or misinterpretation in the agreement. Hence, if there is no consent, there is no contract. And even if there is a consent, that should be a free consent. And the consent is free if it is free of coercion, fraud, misinterpretation or mistake. Otherwise, the contract will be considered as a void contract, and a void contract can't be enforceable by law. The agreement should have lawful object. If the object is unlawful, the agreement is void. Say for example, a landlord cannot recover his rent through the court of law if his house is let to carry on child labor, selling drugs or any other sort of unlawful. Let's move to the next essential of contract, that is certainty of contract. The agreement must be certain to become a contract. Let's understand with an example. Suppose A enters into an agreement with B for selling of nails for ₹100, but it was not clear or certain what is the type of nails or what is the quantity to be sold for the consideration of ₹100. Hence, in such uncertainty, an agreement can't be considered as a contract. So, there should be a clarity. Next is possibility of performance. A contract must be capable of performance. Impossible events can't be considered as a contract. Say for example, Mr. X agrees to bring gold from moon by driving a car. Such impossible agreements can't be enforced by law and thereby does not qualify to be a contract. Next is not expressly declared void. The agreements which are void cannot be enforced by law and hence cannot be considered as a contract. Say for example, restraint in marriage or wagering agreements. Wagering agreements, like if there is any agreement between two parties for predicting the future of any event, say future of any sports, say a cricketing sports. If two parties are involved in an agreement in predicting the win or loss of a team, then that sort of agreement cannot be enforced by law and these are called wagering agreements, and that is a void agreement. Next is legal formalities like writing and registration. It is not necessary that all the contracts must be in written. The contract may be oral, but for the interest of the parties to a contract, it should be in writing. For example, in projects, certain documents need to be registered and documented properly to form a contract and for the interest of the stakeholders are preserved. So this was all about the essentials of the contract. I hope you understand the topic. If you have any queries, you can write to us in the comment box. And we are coming with many more videos about this contract practice topic. So stay connected with us by subscribing our channel and don't forget to hit the bell icon to get personalized notifications, and do share and like, and I will see you in the next video. Thank you and best of luck.